Have you ever felt a weight on your shoulder? The weight of an old injury or a project that never finishes? In court, people also have a burden to carry. The burden of having to prove their case. It's not a surprise that we call this the burden of proof. This burden is different in civil versus criminal cases. In a civil case, for example, when you are claiming money or want to cancel a contract, you will have to prove that the facts of your case are more likely true than not true. In legal terms, we call this the balance of probabilities. The judge will evaluate your proof as though it was being weighted by a real scale. The judge will see which side it seems to lean to, likely true or likely not true. In criminal cases, on the other hand, the burden of proof is very different. The burden is much heavier than in civil cases. A balance of probabilities is not enough. A person cannot be found guilty of a crime unless the Crown prosecutors prove that the accused is guilty beyond a reasonable doubt. In a criminal case, a person accused of a crime is presumed innocent. It is the Crown prosecutors who have the burden of eliminating any doubt about that person's guilt. The judge or a jury must look at all the facts of the case and use good sense to evaluate whether there is a reasonable doubt. It is as though they use a machine that only lights up when the proof reaches the point of beyond a reasonable doubt. If they don't get to this point, the accused person will not be found guilty. Just so you know, in some very particular cases, the burden of proof is different than the general rules we've described. So there you go. To learn more, visit educaloi.qc.ca.